Justice Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the Fair Use Doctrine as defined by 17 U.S.C. 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
Please be seated. Those two are not playing. So he's going to get this. Okay. We're on the record in the case of People versus Linda Stermer. Counsel are present. Ms. Stermer is present. Jurors are all here for final instructions. Any matters to address before we bring them in?
No, Your Honor.
Yes, Your Honor.
Okay.
The elements of the charges discuss causation. Let's talk about the act. The act, it's undisputed, that caused Todd Stermer's death was the setting of a fire. Ms. Zurabine in rebuttal yesterday said you don't have to find arson or anything with the fire, consider the totality of the evidence to find first-degree murder. Everything in every single claim and count talks about the actions of Todd Stermer. The act that caused the death is the setting of the fire. So it was just an incorrect statement by Ms. Zurabine in a rebuttal. And I don't want the jury going back thinking we can talk about the man and the motive and everything else, but we don't have to worry about the fire in order to convict. You have to have the act to convict. So I think the jury should be instructed that there was an incorrect statement, not intentional, but an incorrect statement. The action that caused the death is the setting of the fire. That's undisputed through Dr. Markey.
Ms. Zurabine?
Thank you, Your Honor. I think that's a mischaracterization of what I said. I said that I actually quoted him. I don't have my paper in front of me of what he said, and I said, you can consider all the things. I was referring to strictly, he kept saying if you don't have arson, meaning Mr. Trinkle arson, you have no case, you have no causation, you have nothing. And I kept saying you have to look at all of the evidence. So I think that's a miscategorization. I think it was very clear in my rebuttal. It's certainly, I was informing them that they can look at all evidence. And he said, if you don't have an arson, you don't have a crime. That's the word I heard, and that's the statement I wrote down, and that's what I was addressing. You certainly can have a crime. You can certainly have premeditated murder. You can have second-degree murder, all of her actions together. So I think that's a miscategorization of my rebuttal.
Your Honor, Justin, she said you do not have to find arson. You don't have to find the setting of the fire in order to find first-degree murder. Yes, you do. It's the action of the defendant, which is the fire, that caused the death. So it's a causation issue, and she misstated. I don't want the jury thinking they don't have to find the setting of a fire caused the death, and you can still find first-degree murder on all the other stuff she said.
Or you can still find a crime when you have creating a greater likelihood of harm and death through a second-degree murder as well, which they are being instructed on.
Every single
Counsel, I heard enough from both of you.
Honor.
The jury's here. I'm ready to provide them the final instructions. I'm not going to amend the final instructions. They're going to learn from me what the law is, and they're going to be instructed to follow the law as I give it to them right now.
Thank you, Your Honor.
Thank you. Bring in the jury. Welcome back, jury. Morning. Okay, do they have their final? Do they have copies? Okay. I'm going to provide you the final instructions. We're going to give you copies of them now. Counsel, you both have a copy as well?
Yes, Your Honor.
Okay. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutors must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutors have not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that she did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see and hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has introduced evidence of statements that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you must give the statements whatever weight you think they deserve. In deciding this, you should think about how and when the statements were made and about all the other evidence in the case. You may consider the statements in deciding the facts of this case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You've heard evidence that before the trial, witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witnesses said in the earlier statements when determining the facts of this case. When the lawyers agree on a statement of facts, these are called a stipulation or stipulated facts. You may regard stipulated facts as true, but you're not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutors do not have to prove that the defendant had a reason to commit it, the alleged crime. They only have to show that the defendant actually committed the crime and that she meant to do so. The testimony of Dardita Gordon was read into this trial because she was not available. This testimony was taken under oath at an earlier hearing. You should consider this testimony in the same way you consider any other testimony you've heard in court. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer talked to one of the witnesses, and there's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've heard testimony from expert witnesses. Dr. Michael Markey gave you his opinion as an expert in the field of forensic pathology. Dr. Dave Hayhurst gave you his opinion as an expert in the field of DNA analysis and forensic biology. Ann Hunt gave you her opinion as an expert in the field of serology and DNA analysis. Troy Ernst gave you his opinion as an expert in the field of fire debris analysis and trace evidence. Scott Leroy gave you his opinion as an expert in the field of fire investigation and cause and origin. Robert Trenkel gave you his opinion as an expert in the field of fire investigation, fire suppression, and fire inspection. I'm going to try my best, Zujetsky gave you his opinion as an expert in the field of injury biomechanics. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts the expert gave for his or her opinion and whether those facts are true. You should also think about the expert's qualifications and whether his or her opinion makes sense when you think about the other evidence in the case. During the testimony of Robert Trenkel, videos were admitted as evidence to illustrate his testimony. The parties agree that the videos are not in any way a recreation of the events at issue in this trial. You may only consider the videos to help you understand and evaluate this witness's testimony as it relates to the speed at which a fire might grow and propagate in the absence of liquid accelerants under certain conditions, and how polyester clothing might burn when doused with 2 ounces of gasoline versus how it might burn in the absence of any gasoline. During the testimony of Robert Trenkel, a pair of gray polyester sweatpants were admitted as evidence. The parties agree that these sweatpants are not the same pair of sweatpants involved in this case. They are an exemplar pair of 100% polyester sweatpants. You've heard testimony from witnesses who are police officers, and that testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. In count 1, defendant is charged with first-degree premeditated murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Stermer. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant intended to kill Todd Joseph Stermer. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose her actions before she did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Stermer. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these three states of mind: she intended to kill, or she intended to do great bodily harm to Todd Joseph Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that the death or such harm would be the likely result of her actions. In count 2, defendant is charged with first-degree felony murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Stermer. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these three states of mind: she intended to kill, or she intended to do great bodily harm to Todd Joseph Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Third, that when she did the act that caused the death of Todd Stermer, the defendant was committing the crime of arson. To prove the crime of arson, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant burned a building or any of its contents. The term burn in this case means setting fire to or doing anything that results in the starting of a fire, or helping or persuading someone else to set a fire. If any part of the building is burned, that is all that is necessary to count as a burning. The property does not have to be completely destroyed. Second, that at the time of the burning, the building was a dwelling house. A dwelling house is a structure that was actually being lived in, or that reasonably could have been lived in at the time of the fire. Third, that when the defendant burned the dwelling or any of its contents, she intended to burn the dwelling or contents, or intentionally committed an act that created a very high risk of burning the dwelling or contents, and that while committing the act, the defendant knew of that risk and disregarded it. When there is a fire, the law assumes that it had natural or accidental causes. The prosecutors must overcome this assumption and prove beyond a reasonable doubt that the fire was intentionally set. You may also consider the lesser charge of second-degree murder on this count. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Stermer. It's not enough that the defendant's act made it possible for this death to occur. In order to find that the death of Todd Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these three states of mind: she intended to kill, or she intended to do great bodily harm to Todd Joseph Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her action. The prosecutors must also prove beyond a reasonable doubt that the crimes occurred on or about January 7, 2007 within Van Buren County. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. Premeditation and deliberation may be inferred from any actions of the defendant which show planning, or from any other circumstances surrounding the killing. The prosecutors need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. When you go to the jury room, you'll be provided with written copies of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. I've already given you instructions regarding lesser offenses. As to any count which includes a lesser offense, you must first consider the principal offense. If you all agree that the defendant is guilty of that offense, you need not consider the lesser offense. If you believe that the defendant is not guilty of the principal offense, or if you cannot agree on that offense, you may consider the lesser offense. It is up to you to decide how long to consider the principal offense before discussing the lesser offense. You may go back to consider the principal offense again after discussing the lesser offense if you want to. If you have any questions about the jury instructions before you begin your deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. Possible penalties should not influence your decision. If you find the defendant guilty, it's the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in this case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside of the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. The exhibits admitted will be available in the jury room for you to review. You've been given a written copy of the instructions you've just heard. As you discuss the case, you should think about all of my instructions together as the law you are to follow. Defendant is charged with 2 counts, first-degree premeditated murder and first-degree felony murder. These are separate crimes, and the prosecutors are charging that defendant committed both of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of both or either one of these crimes, guilty of a less serious crime, or not guilty. I've prepared a verdict form listing the possible verdicts. You will have on your verdict form as to count 1, the option of not guilty, guilty of first-degree premeditated murder, or guilty of the lesser offense of second-degree murder. And as to count 2, the option of not guilty, guilty of first-degree felony murder, guilty of the lesser offense of second-degree murder. Counsel, any objection to the fine? Yep.
Thank you.
Did I miss? Additions. Mr. Trenkel, when I talked to you about experts, he was also qualified as an expert in fire origin and cause. And this is an instruction you got at the beginning of the case, but I'll give it to you again now regarding this being a second trial. This case has been tried before, and during this trial you may hear references to the first trial. Sometimes a case must be retried before a new jury, and you should not pay any attention to the fact that this is a second trial. Your verdict must be based only on the evidence in this trial. You must decide the facts only from the evidence that you yourself hear and see in this trial. Counsel, any other objections or additions, requests?
No, Your Honor. Thank you.
Yes, Your Honor.
You're good with the instructions?
Yes, will I get a printed copy of that?
You should have one on your,
Yeah, and they were,
No, I'm talking about
the jury already had it.
yeah, the jury has theirs.
the
Pardon?
added ones, the added prior trial.
Oh,
you don't feel
you're
like
asking
this-
that, does the jury, we'll give them each another copy of the second trial instruction? Okay, we'll add that. We'll just make it up as a second trial. Okay, we're good on instructions then? Okay, so jury, you may recall, way back in time at the beginning of this trial, I indicated that we would draw lots to excuse 3 of you. The first person we're excusing is by stipulation of the parties, and it's not random. But the other 2 names we're calling will be randomly pulled. If you're one of those persons, we're going to get you. Call you back in as a juror and begin the deliberations anew. We will call you when the jury has reached a verdict, and once you get that phone call from us that the verdict has been reached, then you can talk to anybody you want about the case if you wish. Okay? So we'll call the names.
You do solemnly swear or affirm that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them, orally or otherwise, that you will not communicate with them or any of them, orally or otherwise, except by the order of this court, or to ask them if they have agreed on their verdict until they shall be discharged. And that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon.
Okay, jury, you can take your notebooks with you, and I'm directing you to the jury room. Council, any matters to address?
No, Your Honor.
Any public waiver? Okay, thank you.
Thank you.